Subcommittee.
Wait, hold on. We're not exactly live just yet. It's preparing. It's taking a moment. We are live.
Good afternoon, everybody. This is a meeting of the Criminal Law Subcommittee. We have two bills on tap for discussion today. HB 16, which is regarding ICE detention facilities, and House Bill 234, which is related to service animals. We have some timing constraints today for some of our members, so I'm going to start backwards with House Bill 16. The bill does a few things. We've seen it at least a couple times in this committee. You will recall that it would prohibit state and local government from essentially contracting with private facilities or private companies for immigrant detention facilities in the state. It would take existing agreements with ICE and wind them down by October 1 of 2022. There are 3 counties that appear to be impacted by this the way it looks: Frederick, Howard, and Worcester. It also has provisions that would require zoning input, essentially, to build a private immigration detention facility. So I think that would be in the instance where the feds have contracted with someone to put a facility in Maryland. Again, most of these are sort of prospective, hypothetical provisions to sort of impede the possibility of these facilities, but the actual change in the real world, as I understand it, would be to the Frederick, Howard, and Worcester programs. Lastly, there's a clarification that this bill does not, it's neither here nor there with respect to the 287G programs throughout the state. So that's the bill as it's before us. There are no amendments. I would like to try and call this for a vote today, since I think we have formed feelings on this, but happy to just talk about it for a minute. Delegate Fisher may have to jump in a minute, which is why I'm trying to see if we can just kick this thing. And just, you know, for purposes of transparency and opposition, were Mako and Worcester County. Howard County does not appear to have a position, or at least they're split. The council voted 3-2 to not have the facility. The executive vetoed it at last check. And in Frederick, I believe you'll find no position from the county government over there. And in terms of the advocacy groups that wanted this, it was the Attorney General supported this in principle. The AFSCME correctional employees supported this in principle, the ACLU, CASA, and other groups. So that's the bill. Do I have a motion on the bill?
Move favorable.
People have their hands raised. I don't know if we can do this out.
Sorry, let me grab the, sorry, I apologize. I don't have my chat and hands open. Okay, I see some hands. Delegate Davis.
Second.
Okay.
Why isn't it going through?
Delegate Fisher.
I just asked.
My hand was raised to make a motion.
Okay.
So I'm done.
Delegate Erican is next.
Thank you, Mr. Chair. Could you just explain again what is the difference between what 287G is and this program that we're trying to impact? What's the difference between those two? So they're not. This isn't talking about 287G. It's something totally different.
Yeah. So and some of the experts here can jump out if I get this wrong, but 287G is about detaining the immigrant and sort of, you know, handoff between proceedings. But what this bill, and it's trying to clearly get at it with a provision clarifying that it's not about 287G, is getting at state and local governments basically in the business of immigration detention and entering into various agreements, either with private companies by way of the government or with agreements directly with the federal government to raise revenues by having these immigrants detained here.
So there's like private prisons in those 3 counties, and the private prisons are used by the federal government?
Yeah, look, if people say, does Maryland have private prisons? I say no, asterisk, and the asterisk is this sort of arrangement that we have where these counties are taking revenue in order to detain these immigrants, not as something they were doing in their ordinary course of business. They were doing it as a revenue item.
Okay, so inside of already existing prisons that are owned by counties, there's a place where they're using those cells for ICE detainment, and they're charging the federal government to do that. That's what's happening.
Yeah, and it's a little bit more jumbled too, because I believe, say, some of the county facilities are just for this, and some have mixed purpose, and so you can't quite divide it out. But the bottom line is there is money being changing hands in order to provision the imprisonment of immigrants, and that is a contracted agreement between the counties and the federal government. So, and just on that note, the 3 counties under the bill would be phased out of their existing agreements by 2022.
So then they would have this space available that they wouldn't be able to use. So this really feels like another bill we're crapping on local courtesy, doesn't it? I mean, this is a private contract they've made with the federal government. What are we doing? I mean, this is another bill like this again this year. It's crazy.
Delegate Moon, if I could add, part of the reason this is not really just a local issue is that when these bed rental contracts are in place in just a few counties, in reality, ICE actually detains people from across the state and sends them. So if you look at the Howard County facility, many of the people who were actually detained in Howard County were from Prince George's County. So it really goes beyond the parameters of a local issue.
Well, I'm talking about the local issue, not in respect of who's inside. I'm only talking about this is a county making a private contract with the federal government. That's definitely a local issue. It doesn't really matter to me if they came out of the state or whatever. If the federal government needs a location to house people under the federal laws that passed probably bipartisanly not that long ago, and now we're telling counties that their contracts, that we're going to supersede their contracts with the federal government, and when the federal government's acting completely lawfully, this is terrible. This is a terrible idea.
Delegate Conaway has his hand up.
Yeah, so in reference to that, Chair, if a person is detained in Baltimore and they're sent to one of these counties, then the county gets the federal funding, but Baltimore gets nothing. Is that right? The answer to that, I guess.
That would be correct, yes.
All right. How long might someone be detained in one of these facilities before they're picked up by ICE?
It could be a long time.
How long? A year? 6 months?
I think that's right.
Okay,
longer.
During that time, would the person might be working in a detention center?
I don't think so, but
assigned to work detail?
I don't know the answer to that question.
You don't have an answer to that? Okay, go.
This is Mark Fleming from the National Human Justice Center. I'm sorry that my camera is not working, but I'm happy to answer that question.
Yes, Mark, please.
During that time, there is a program that they refer to as the Voluntary Work Program, in which folks that are detained, and I'm not certain as to these 3 counties whether these programs are in operation there, but it's where they pay them $1 a day to work, to basically run parts of the facility, whether it's laundry, helping with cutting hair, and food service and things like that. So that there are programs like that in ICE detention facilities.
Okay, Mark, I hate to cut you off. We're short on time, but could they possibly be helping to make the COVID mask?
I don't believe so. There's not programs like that in ICE detention.
Okay, thank you.
Delegate McComas is next.
You're on mute, Sue.
A number of people who said, who were opposed to this bill were concerned that what's going to happen is that a lot of the folks that are detained are going to be out of state and they're going to be further away from their family and their connections, their community connections. And I think that's probably true. I know Harford County, we have a detention center that was built for lots of criminals, and unfortunately they haven't filled it up. So they benefit from the 287G, but that, you know, it's a county facility. Mr. Sanderson, you know, MACO has a legislative committee, and he would not have written that letter opposing the bill, saying we are basically co-opting local government authority and control with this bill. So MACO does not support this bill. I think the fact that it's been in, I think, 2 times and has actually never had a vote, and in other words, it just sort of stalls out in committee and hits the drawer and is sealed for that session. I think this is a problem looking for a, this is a solution looking for a problem. I think I'm also kind of surprised that I think this is another Delegate Cosby bill where another jurisdiction is going to mandate what other jurisdictions should do or have statewide legislation, and there's no rationale for it. I'm not hearing that these, you know, if they're going to build a facility, they have to go through the zoning of the county anyway. So we just don't have to put this like kibosh to this whole thing. There would be public input. All politics is local. So what we're doing is we're making a mandate that none of these counties can even do this, or even you know, if they have a facility that they can convert and that's been empty and having trouble paying their taxes. This is something we shouldn't be getting into, because we don't know all the different problems that all the different counties have. And as like everybody likes to say, Maryland is America in miniature. And the Eastern Shore is different than Montgomery County, than Prince George's County, than Western Maryland. And in other words, I adamantly oppose this bill. This is stupid. And I think we should vote it down.
Delegate Grammer is next.
Thank you, Mr. Chair. A statement and a question. So Maryland or local jurisdictions do in different accounts have these detention centers that a jurisdiction will house folks who are being detained on behalf of the federal government. For example, there is one in Baltimore City. They house mostly like egregious offenders, murderers, people who have committed acts against children, sex offenders, and such. So this is done in a lot of different places, maybe not as far as detention of immigration enforcement, but it is done elsewhere in the state. And I just wanted to put that out there so everybody knows. But I have a question about some of the language in general, and I'll give you an example. Usually there's parts of a bill that, you know, clearly define what the law is or how a agency should function. This bill has some statements in it that they're more of like general statements of principle than would be reflected in a bill where it's enumerating statute. And I'll give you an example.
Delegate, can I stop you right there?
Sure.
If you don't mind.
Sure.
I actually had a question about this too for council, and this was just on the question about, there is a sort of whereas style section of the bill. Is that is that kosher, I guess, in drafting here?
Which section, Delegate Moon?
Let me ask you, and this is a bigger issue, and I'll give you an example. Page 3, line 27. Detention requires the exercise of coercive police powers over individuals that should not be delegated to the private sector and is distinguishable from other governmental functions that may be privatized. Now, typically in a bill, it would say something like detention may not be privatized for the purposes of X for a local jurisdiction. But this is kind of like, if this is law, does that mean the state or a local jurisdiction can't have an agreement for private detention? Because that's the way it actually reads.
Yeah, it's a question about this section 1102 section, findings of the General Assembly.
Yes, I'm looking at it now. You want to know if that's
Well, does
typical?
it is it sort of a sort of expression of sentiment, or does it have some legal effect beyond that?
So,
And I guess that's one question. And the second question is, are we allowed to insert this kind of non-binding sentiment in?
Well, that's the hitch, because if it's law, it is binding. I mean, that's the way if it were a whereas statement, it would be a more expressive, it'd be more expressive text, but this is
so it
actual
wouldn't be
statute.
codified as the
Right.
whereas. Here it's codified. So I'm happy to ask to ensure this, but I would think that, sorry, they're doing construction outside. But I would think that once codified, the background for the bill would be here in that language. So it would be implemented, so to speak,
Well, does that mean,
as part of the bill.
does that mean it, page 3, line 27, that this bans privatization of detention centers? That's the way it reads. And that's a bigger policy question than goes
Well, it's
beyond-
clearly the aim of the structure of what's actually operating in the bill is attempting to outline through a few ways how they're trying to stop private immigration detention facilities. That I think is true. Well, I'll tell you what. I mean, here's the reality. It's March 11th, and we're running into crossover, and so. Well, let me ask the sponsor about this 1102 findings section and what the sponsor intent was.
Yeah. Thanks, Mr. Chairman. My preference would be to cut the preamble. I believe that was some language that was left in from the California version of the bill where this sort of finding language is typical. And so it's honestly my bad for keeping it in. And so I'll take the hit on that, but my preference would be for the committee to strike it. And I think that Delegate Grammer's concerns are well founded.
I mean, I don't have a problem with the content, to be clear. It's more, I don't know that I've seen a finding in a bill that we've pulled through the subcommittee before. So
yeah, I mean, I of course don't have a problem with it. Yeah, sorry, I don't have a problem with content either. I just think this is kind of the difference between states and how they do these things. And I think we transposed this from a similar law and basically didn't take this part out. So I'd be totally comfortable with striking the whereas, not the whereas, but the finding section.
Yeah, and I love you, Delegate Stewart. I'm not trying to be clear, I'm not going to support the bill. I just think if we move bills from this subcommittee, they should be, even if we don't agree, they should be clear about what we're doing. There shouldn't be oddities in the text.
No, and I love you too, and I didn't think you were going to support it, but I do think this is a good thought, and I appreciate it.
And so to be clear, this preamble bit is modeled after a bill that passed in California.
Yeah, that's correct. Illinois, California, and Washington State have all passed versions of this, and so we've used kind of an amalgamation to craft this bill, and somehow that language was left in from a draft. And like I said, it's my bad.
Okay. All right. All right. Well, is there a motion on the preamble then?
Yes, there's a motion to strike the preamble.
Is there a second?
Second.
All right. All in favor of striking the preamble, raise your hand. Any opposed? No.
Motion to move the bill.
All right. So the bill has been moved and seconded. All All in favor of House Bill 16 without the preamble, raise your hand.
Mr. Chair, I think Delegate Jones is logging on. She got the time wrong for this committee meeting. So if you can hold on a second.
Oh yeah, she's in the waiting room. If
Yeah,
she
she's
gets her
coming.
hand
She just
up right
messaged
quick.
me.
Let's
So if you
see.
could repeat it for her, because I know she got confused.
So there's a motion to a favorable motion right now happening on House Bill 16, the ICE detention facility bill, and it has been amended to remove a preamble that we don't sort of do in Maryland. So a hand up means you are in favor of House Bill 16 to phase out ICE detention facilities in Maryland. All right, so actually let me make this clear by writing it down.
You might not need to raise your hand, Mr. Chair. I think you
I
might.
got you. All right, any opposed? Oh, this is a surprising.
I know, right?
Um,
Never have guessed.
all right.
Mr. Chair, may I be excused? I have a judge calling me.
Yes, please.
Okay, I will
thank
be
you.
back as soon as I'm done in court.
My apologies for my delay. I was confused.
You're good. You caught it. You caught it at the right time.
Can we get the count on the roll, please?
Yeah, it was 1, 2, 3, 4, 5, 6 yes to 3 no.
Thank you.
Party line. All right. We are now on House Bill, I believe it's 234. You will recall this as the bill that deals with service animals. The bill as introduced did two things. It created a 5-year penalty on interfering with or killing a service animal. And it also had a provision requiring mandatory restitution for these offenses. I believe the sponsor is with us with amendments. If you would like to explain them.
Yes, thank you, Mr. Chair. I do have some amendments just based on conversations as well as feedback from this subcommittee. I don't know if the amendments got to everybody. I'm happy to share my screen if allowed to show the amendment. But what it does, so it modifies what was the previous amendment to separate out the penalty for killing and reckless, make it different from interference. And also too, instead of, I know people were really concerned about the may in terms of the restitution portion. And so we modified the language slightly just to say that the court shall consider an order for restitution as opposed to having a flat out shall enter an order of restitution. I haven't spoken to the judiciary directly to see if they're okay with that, but I know that was a concern. And so, so I raise it as kind of a way to kind of split the baby there about that concern. And so I wanted to offer that to the subcommittee to see if that amendment will alleviate the concerns that were raised previously. Also to the amendment, I think does modify the penalty. Let me go back, let me pull this up. And like I said, I'm happy to share my screen on this. Let's scroll back up. So it still is amending section 10-608, but it does amend the penalty. So it's a misdemeanor with 2 years or a fine not exceeding $2,500 or both for the intentional and reckless. And then for the interference, it's a misdemeanor as well at 1 year with a fine. Let's scroll down. Where is my fine? Where did you go to? I believe it's like $1,000. So those are the changes with the most recent amendment. Oh, my battery's running low on my laptop. Okay.
I have a question, Mr. Chair.
Sorry. Okay, I guess why don't we go to, we have a bunch of hands up. Okay, Delegate Cardin.
I think his was left up from before.
Right, I'm gonna lower his hand. Delegate Conaway.
Thank you, Mr. Chair. So to the maker of the bill, what does interfere mean? What does that mean?
So interference obviously is not the animal's killed or the animal is injured, but hypothetically speaking, say another dog goes and tries to strike at the animal, as the animal is performing its service as a service animal. And so the animal is not physically injured, but it is being interfered with in being able to assist the disabled person in performing its duties.
So you're saying that if I have a regular dog and you have a service dog and my regular dog attacks your service dog, then we have this extra fine here?
Well, what could happen is though the dog will now become they will be unable to use the dog because now the dog has psychological trauma. And so the dog would no longer be able to be used as a service animal in the hypothetical I just gave. I see Jennifer, and I have a couple of the advocates here on the call that can maybe also speak to this as well. I see Jennifer Bevan-Dang.
So in your theory, no. In your theory, if my dog gets out of my control and attacks your dog, which is a service dog, then I could be in prison for that?
It would be, the interference of that, and actually this isn't new in the law. There's actually already a provision currently in the law, I believe. So we're just amending this section to include service animals. And so I think this also currently applies to equines and things like that, which is already currently in the law, Delegate Conway. And so, but the service animal will no longer be able to be used by the individual. And as I mentioned during my testimony, I mean, these animals are extremely expensive. The average cost of a service animal is roughly around $60,000. And so it's not as though, they're injuring another dog that you would just simply get from PetSmart. That's not exactly how these.
Okay, I understand what you're saying.
Right.
It seemed like my stupid dog should know that this is a specially trained dog and not to attack that dog.
Well, but you have a duty as the owner of the other dog to make sure that your dog is not harming other animals. I mean, that's just generally, whether it's a service animal or not.
Right, but what I'm asking is if my dog gets out of my control by mistake, I wouldn't fall under this bill. I mean,
I think mistake and interference are two different things. And I think that will be something that the trier of fact, if this case were to actually go to court, would decipher between.
Sure.
Delegate.
Sure, I understand what you're saying. Interference, my dog definitely interferes with your dog and is going to bite your dog. But the dog got loose from me, or the dog jumped the fence. It was my dog. I'm no problem with that. The dog did something it wasn't supposed to do. I don't know that my dog knows that your dog is a special dog, and now I could be in prison for that.
Well, you have a duty, as I stated.
I understand that. Is the answer yes or no?
Yeah, Delegate Conaway, let me also read you some of the section of law regarding the existing terminology around the crime of interference in Maryland. And it's willfully and maliciously interfere with, which is clarified with injure, destroy, or tamper with. And so the original law is based on racehorses. And so I think the idea is that if there's a category of animal that has a different value to it than an ordinary animal. And I think they were thinking about messing with a horse race in particular.
Yes.
To try and throw the race. They put this law together.
Sure.
And so they say in that context that interfering with is to willfully and maliciously interfere with, injure, destroy, etc. So it's something more than an accidental behavior, and it requires a malicious intent.
Delegate Moon, may I interrupt for a second? Because
Yes.
I think there could be some confusion, or maybe Delegate Williams can help, because there were 3 sets of amendments, and the one amendment that's going to the point that you're talking about on putting this language into the racehorse statute does not talk about willfully and maliciously. It specifically just says interfere, and it has language interfere ... by obstructing, intimidating, or otherwise jeopardizing the safety of the service animal or its handler. And then that set of amendments also it could be a drafting issue, or it could have been intentional, but it looks like it's in the cockfighting section as well, and it's repealing the felony of aggravated cruelty to animals for cockfighting, in addition to making this new crime a misdemeanor. And then finally, it doesn't repeal the new language in 10-626. So I just see a few problems in this amendment that I'm not sure if I have the most accurate or up-to-date version.
Yeah, so that amendment was supposed to repeal 10-626, Lauren. So that's a drafting error.
Okay.
Supposed to repeal that.
I can definitely take care of that.
Okay, okay.
But what about the other 2 issues?
And then the other 2, I think the intent was to keep the same intent as it applies to the equines, with the willfulness and the maliciousness.
Okay,
So let's just talk about this conceptually, I guess, for now. So I guess the proposal, I just want to understand, I guess, what we're trying to do with the proposed amended version. It would be on the restitution. What did you do? That basically you changed it from a shall to a may. Does that sound like the gist of what you're going for? Or was
Yeah,
there
it just
something
simply says
more?
that the court shall consider an order. So they just have to consider it. They don't necessarily have to grant it or anything along those lines as it relates to the restitution portion of the bill.
Do they have to say something?
They just have to say that they considered it and felt like the facts of the case that didn't warrant it.
Okay, well, can we just talk about the restitution part then? How do folks feel about that aspect of what's attempted here?
Actually,
like the
that
change.
was part of my question, if I may, Mr. Chair.
Oh, yes. Oh, sorry. You want to get back into the role? Let's do it. We got Delegate McComas next then.
You're on mute still, Sue.
Thank you, Mr. Chair. I am not in the statute area, but if someone is going to harm this animal maliciously, or let's say gross negligence, usually people that harm animals, there's some other issues. And so is there a provision that if the judge feels it's necessary, get a psychological evaluation of the person or have them seek counseling?
That's not included in the bill.
Okay, do you think it would be appropriate? I mean, one, the person, obviously it's a service animal. Now if the person's blind, it's obvious that they need it. If it's a service animal for a vet or because of their psychological problems, it may not be as obvious, but I'm just wondering if that, because a lot of animal abuse is a red flag for further problems down the line with the person.
Mm-hmm.
And so that's why I'm just wondering if there should be a component.
Can't a judge already order that?
I guess in theory they could.
I can jump in and help if Delegate Williams's amendment, which it looks like if this ends up happening, she's trying to amend 10-608 of the criminal law article, which is the provision dealing with cockfighting. And in that part of the code, it does allow, as a condition of sentencing, the court to order a defendant to participate in and pay for psychological counseling.
Okay, all right. So in other words, it's going to go in that section so that would be an option. Correct, Holly?
Well, correct, if these amendments go forward, it looks like there's some discussion going on about how this is actually going to end up. So I have a few different versions, but I think I'm looking at the right one. And she's attempting to put part of the crime in 10-608 dealing with cockfighting, and then part of the crime is moving for interference. So the part about killing, recklessly killing, or intentionally or recklessly killing, she's going to put into the same as the cockfighting. And then the provision about interference, she would like to put into 10-620 of the code, which is dealing with interference with a racehorse or horse. So the part about the killing would allow the court to order the psychological counseling.
Well, okay, my question is though, that the animal may not be killed, but let's say it's a pit bull and you know that, you're walking the pit bull and you know that animal's kind of vicious if he happens to see somebody else, and you don't have good control of the animal when you're walking it. They could really maim an animal.
But that doesn't go to the psychological aspect of the owner, which I think is what
it might.
Look, for clarification purposes here, that provision about a court may order this evaluation or psychological services, it appears in all of these aggravated animal abuse. So it's abuse, aggravated cruelty to animals, dog fighting, cockfighting, all has this. And these are the felony animal abuse, comes with 3 years, up to 3 years on these. So if we're looking for consistency in when the psychological evaluations come with your sentence, it would be if there's some portion of Delegate Williams' bill that we think falls under the aggravated animal abuse penalties, felony 3 years, possibility of psychological services. So the question would be, does killing someone's service animal put that defendant into this, possibly into this aggravated animal abuse category? The way the bill is written right now, it actually puts 5 years on interference and killing in the same basket. And the way the law as currently written separates it a bit so that if it's an aggravated killing, it's a 3-year felony. Interference of a racehorse or whatever is 1 year. And then there's this middle area if you kill the animal, but it wasn't particularly cruel.
Right. Which I totally understand the need to separate that out, which is why I offered the amendment. And like I said, I'm willing to add the willful maliciousness in front of the interference to make that very clear in the amendment there.
So if we accept this, just committee, what I would propose is there's really 3 questions. There's what to do with the mandatory or optional restitution for a service animal that's been harmed. There's what we want to do, if anything, on interference with a service animal. And there's what we want to do, if anything, on killing of a service animal. So it's really 3 separate questions. And really, there's existing law, as we've pointed out, but versions of the bill are written in a way that would create new sections, which, we can do that too. So that's it. But yeah, all right. So there's a lot of hands. Grammar would have been next.
Thank you, Mr. Chair. I have 2 questions, I think, for the sponsor. I don't have objections to restitution, but I just like for it to make sense in relationship to other parts and other similar parts of the law. Can you help me? I wouldn't want to create a restitution situation for a service animal to be greater than like if I beat up someone and lit their car on fire. Can you help me understand how this restitution relates to a similar situation elsewhere in law?
Yeah, so the restitution provision doesn't specify a specific dollar amount. Delegate Grammer. It just simply talks about some of the things that for the courts to consider, such as the value of the service animal, the cost for replacement or retraining of the service animal, and handler, veterinarian expenses, or medical expenses to the handler, or lost wages or income. So it doesn't specify a dollar amount, which I think in any other case, if someone was seeking restitution, the court would weigh kind of the harm to the victims in those situations anyway. And so that's what this provision would do.
Yeah,
So,
and I'm looking at it now, and I could just read by the things that they're considering, like this could get very pricey very quick. So are these things that would be considered in any kind of this liability situation?
yeah, I mean, I think if you have a victim, they would consider whether or not, the victim has, lost wages, or if the victim had medical expenses. I mean, all of those things would still come into play.
Let me ask this. I think I have a more direct way to ask. Several years ago, there was the big pit bull discussion, and they put in place strict liability. So if I have a pit bull, it gets loose, it attacks a person. How does this compare, the restitution situation in that case to this case? Can you comment on that?
And I guess I'm going to maybe lean to Jennifer a little bit on the strict liability thing. I'm not certain if that's still, I know there was a case back in the day on that, but then it got amended through amendments by the General Assembly, but I don't know if that's still the law, to be quite honest, in the state of Maryland, that pit bulls inherently are dangerous. I know that there are local jurisdictions that may have that law in the books, but I'm not aware of the state having a law that owning a pit bull is strict liability.
Yeah, they avoided the pit bull question altogether, and what they did is they said you're strictly liable. Well, I'll ask one final quick question. I'm with all the amendments in the discussion and touching different parts of the statute, I'm starting to lose grasp of what the totality of the bill looks like. Would you be opposed to us getting an interlineated copy so we can?
No, that's fine.
Okay.
I can get you guys that.
I would, if you could work with her, Mr. Chair, and I'd very much like to see it so I can understand what we're working with. Thank you.
Okay.
Delegate Erican.
Thank you. So a couple of things. First, I will say I have owned aggressive dogs before, and what we were told was if you know that you have an aggressive dog and your dog has a second incident, you are strictly liable for that. So I don't know if it's on the first.
That might be county. I know that some county jurisdictions have some provisions to that effect, Delegate Erican, but I'm not aware of a state.
Okay, maybe it's county. It was a couple.
Am I correct in that, Jennifer? I don't know.
Yeah, I apologize because I came into this role after this committee did a lot of the work around the aggressive dog issues. I do think there's a difference between how the judge would determine restitution based on the impact to the victim versus the strict liability question. I think those two pieces interrelate, but the strict liability doesn't sort of set a legal precedent for the judge to then find full restitution.
Right. Okay. Yeah. So, and by the way, they were not pit bulls, neither of them. They were Anatolian shepherds. So that's one comment. The other one is I'm not sure why we're lowering the penalties. If I heard that right, for cockfighting, why are we doing that? I think the chair said it went from a felony to a misdemeanor.
Yes.
You'll recall there was some discussion about that last week from Delegate Davis towards the end of the meeting. That's existing law in this section. And this was sort of the challenge. That section of animal cruelty is felony offenses. So they're 3-year felonies. And so Delegate Davis was asking about that last week. And so I gather this is responsive to that conversation.
Oh, I don't remember the conversation now. I'm sorry. It's been a long week. Yeah, I guess I'm always uncomfortable with making crimes against anyone less penalty. They don't get the full penalties ever anyways. So why are we dropping the bar down. So I'm not a fan of that change personally. But I think I like where this bill is going, and I'm glad that we've figured out putting in there that he needs to be willful, because I think that's helpful. I wouldn't want Delegate Conway to go to prison because his dog that he did not know was aggressive accidentally interfered with someone's dog. We would miss him.
Right.
And
And
my dog thought that you were bothering me because I passed. I'm sorry.
You were bothering me because you passed.
All right. Well, we
I
don't.
did not forgive you for that.
Like we would
don't
be
wanna get
concerned
involved.
about
Guys,
changing the existing cockfighting statute. With all respect to the sponsor and the work happening here to amend the bill, we understand where the amendments are headed with the bill, but we would respectfully request that any changes to the cockfighting statute be a separate conversation.
Okay.
Agree.
Okay. And my office is sending an interlineated copy now to everyone on the subcommittee. But understand, Jennifer and Lisa, thank you.
So we have about 8 minutes left. So let's quickly wrap questions, and then we will have to grab the interlineated copy and pop back on the next round. Delegate, but I want to do some straw polling here, though. All right, Delegate Cardin, you had a hand up.
Thank you, Mr. Chairman. And you didn't call on me the last bill, so I thought that you were sending me a message. For three quick things. First of all, I thought that in the beginning of the discussion we were changing the restitution from a shall to a may. Is that true or not true?
I'm like, if it's the will of the committee, I'm happy to do it. I know the restitution portion for some of the advocates is extremely important.
My comment on that is, I like the bill. I'm going to vote for it no matter what we do with it. But if we change it from shall to may, then the strict liability issue is irrelevant, number one. Number two is the court's discretion in terms of the amount. The court can then look at what they think is appropriate. So, that really, and I think the court can do that anyway, even if it is a shall. So I wouldn't worry about the restitution side on it. In terms of the penalties for jail, going back to Delegate Conway's comments, if there is a requirement for intent, right? A willful intent, is that true? Okay? So
that was the intent.
Wouldn't it be true, Delegate Williams, talking about Conway, that if it's determined that you didn't have the intent to let your dog out, and really it's not dealing with other dogs hurting dogs, but although I guess that could be an issue, but people hurting dogs, if you didn't have the intent to interfere with, then a judge is probably going to find you not guilty of this. Wouldn't that be the case?
Yes, that is correct.
So I wouldn't worry so much about people making mistakes. I mean, obviously, if mistakes happen, there can be a civil suit and we can come up with a settlement anyway outside of the statute. I think this is a great statute, and I think we should just move it forward.
He froze right on a conclusive statement, though. So good for him. I think we have Delegate Conway again.
So thank you, Mr. Chair. So Delegate Cardin, are you saying that we don't need the willful?
He's frozen. He's frozen.
We lost Delegate Cardin.
What are you guys saying? Are you saying we don't need the willful? You think he's saying?
No, I think we do need the willful. I think
okay.
We need the willful.
We need the willful.
Yeah.
Okay. Well, I would appreciate
I'm okay
that.
with that. I don't know if the advocates have a concern with it.
Okay, but I would appreciate that, Delegate Williamson. Thank you.
Okay. Okay. Thanks.
Okay. So conceptually, we are hearing the restitution would go from a shall to a may, and you have interference as a 1-year offense that's willful, and you have a proposal, these are all proposals, excuse me, and you have a proposal to amend killing a service animal into a misdemeanor with what penalty on that?
Go back to it, hold on. 2 year, a max imprisonment of 2 years or a fine of 2,500 or both.
So that would be sort of a new middle category.
Right.
Can we make a motion on the amendments?
We were waiting for an interlineated copy of all of this.
Yeah, and the interlineated copy is not going to have the willful or malicious in there, unfortunately. I mean, I'm happy to.
Right, but you said it, so we know it, and we can put it in there. So can we make a motion on accepting the amendments that you just?
Can we have council draft up and hypothetical interlineated? I'm not opposed to any of this. I just like to know what I'm voting on here, and I'm starting to get some language creep.
Okay.
And I like the bill, just for the record.
Look, but let's do this.
And I need
Let's-
to deal with the
let's-
cockfighting thing too.
Let's try not to. Is Delegate Cardin back?
I don't see him unless he's in the waiting room.
Okay. It would be better if we had some, because we're running shorter on time these days. We will meet again, as needed. So I wouldn't be concerned about that. But I don't think we should be in an endless loop of amendments if we can just try and hash a little bit out. It doesn't sound like there's controversy on the restitution part, right? And it doesn't sound like there's controversy on a willful, if you're intending to willfully and maliciously mess with someone's service animal, there being an offense there. Are folks comfortable with adding the willful and malicious interference with a service animal to put that crime on par with doing it to a racehorse or an equine, excuse me? Raise your hand if in principle you want to add service animals to the interference with racehorse, or excuse me, I keep saying that, interference with equine.
I have a question. A question. So if you remember last year, we got into this specific part of the language, and it was like getting into felonies, and it came out that the equine laws were about their relationship to gambling. And I hate to be that guy, but I just kind of want to look at that. I don't know.
Delegate Graham, my office said that it should be in your inbox. The interlineated should be in your inbox now.
Okay.
And we amended that section, I think, as a result of that discussion last year. I'm pretty sure the interference with equines was a law that we touched last year. Yeah, Senator Huff had a bill on that, I recall. And I think I
remember that one last year too.
I think they defelonized it.
Yeah, it's a misdemeanor in the existing law.
What section is it, you guys?
I think that's 10-620.
We did this too. I remember this bill.
Yeah, no, we had this bill last year.
I thought it was weird that it was a felony for just a.
Yeah, I'm pretty sure they defelonized it last year.
But to me, this issue is different than that issue. I mean, that's more about like an income earning business interest. This is like somebody's existence in society. So, but it's fine. I think we should match it the way it is now. I think the penalty is stiff.
And what does this interlineated copy not include? The malicious, intentional? Is that
correct?
And where that would be in item 4, is that?
It would go, hold on, let me pull up my, scroll up. So yeah, it would go under number 4. So if you're looking at 10-620, right now, number 4 just says interfere with the use of a service animal. And so we would make it the same as number 1. And so we'll say willfully and maliciously interfere with.
Okay.
And this in existing law is that's a 1 year, $1,000 misdemeanor.
Okay. So there is a scenario it's the Delegate Conway scenario. Okay, we're talking about malicious interference with an animal. It's purposeful. There is a scenario that Delegate Conway mentioned. The dog jumps the fence, kills the service animal. That's clearly not malicious or intentional. The advocates want us to address that as well. Do they not
This is
care?
a person may not.
Okay. Okay.
So again, we're just talking conceptually right now. I'm just trying to straw poll sentiment here about whether this is a route that seems viable to add service animals willfully and maliciously interfering with a service animal into the section about equines used for racing, breeding, competitive exhibitions, or any other lawful activity. So equines, I think. Horses.
Okay.
Mr. Chair, I'm not opposed to doing it. If I was a stickler, I'd probably create a different section just for service animals. But that just
Can I jump in? I'd have to say I'm starting to agree with Delegate Grammer on in only one way, not in only one way, but for another reason, which is if you're not going to change the cockfighting felony language, I don't think we want to put these service animals into the cockfighting statute. And so I think then that makes the argument to me that the bill you should start with the original language version with the whole section in one place. And then we maybe separate out the two penalties, as Delegate Moon was suggesting, where we have a separate penalty for the killing and then another one for the willful malicious interference. Then we change the restitution to may, and that could, and then it would all just be right there.
I love that. Yeah, I like
that. Sorry, that last part sounds clear to me. It's the killing part that I'm a little confused on. So in that scenario, where do you think, or how would we handle the killing?
So this applies. So this is a decision, a policy call for you all to make in all versions of Delegate Williams' amendments. Her language would talk about a person may not intentionally or recklessly kill or allow an animal that the person owns, to kill. So that's how she is proposing to handle the killing. So however you handle that, I would say you would have a section just like in her original bill that says a person may not, intentionally or recklessly kill a service animal. And then the language about the person may not willfully and maliciously interfere with, each of those having the separate penalties, the lower penalty for the interference and the higher penalty for the killing. But it's up to you how you want to work on that language and how you want to talk about the killing and the interfering. And then within that same section, we would have the definition of service animal would stay the same. And we would have a section that says the court may order restitution and the list of the court may order.
I understand intentional. What is the purpose of reckless?
Can I actually just flag here too, because I have the existing law open in front of me as we do this, and the other sections of law don't have recklessly. It says intentionally on the aggravated felony killings or mutilate, whatever. It says a person may not intentionally, and I guess so. I'm just flagging this is a difference. So this would now say intentionally or recklessly.
Delegate Williams, do you have a purpose for recklessly, or are you okay with us striking that?
I mean, reckless is just a different standard. And so that was why it was included.
Can you or the advocates give us an example of reckless?
Let me go back to
someone being drunk.
No, you're good.
I mean, I could see a scenario in which someone was attempting to harm the individual who uses the service animal, and the service animal intervened and ended up being the one that was injured instead. And I apologize for the barking dogs in the background. I can see an argument for reckless in that if someone is trying to cause harm, I think that reckless is a factor that the judge should be able to consider.
What about if somebody is inebriated if someone is inebriated and just starts that behavior while they're drunk.
So, sorry, let me put this back into perspective. So can the sponsor remind us again what the proposed penalty is on the killing if the animal dies?
Or I believe that's the 2 years, $2,500, but let me just double check myself on that. I don't always trust my memory.
So if you
2
cruelly,
years and $25. It's a misdemeanor, 2 years, $2,500.
I just want to square the code here. If under current law, if you cruelly beat or kill or engage in sexual contact with an animal, our law has that as a 3-year felony.
Felony, right.
And
But I don't know
so,
if that rises to that. I mean, that I seem.
yeah, no, I got you. So you're saying you would get stepped down, and a step down would then be this new category, which is that you intentionally or recklessly killed an animal and the animal happens to be a service animal, that would be a 2-year misdemeanor. And if you killed an animal also intentionally or recklessly, but it wasn't a service animal, the penalty for that would be what? Does anyone know the answer to this one?
The killing of an animal, which is a different section of the code.
Yeah, I just want to know what does the service animal difference lead to? If I kill an animal in the exact circumstances, cruelly or intentionally or recklessly, but it wasn't a service animal, what you get for that? What you could get for that?
If you poisoned a dog, willful or maliciously, you have a misdemeanor and a fine not exceeding $100.
Delegate Davis, let me ask you a question because you practice. Is there a value in separating intentionally, recklessly, and unintentionally?
Well, it creates a weird diversion in how we look at this, I will say.
Because look, if someone kills a dog purposefully, that's one thing. If they're in a fight and they fall on the dog, that's reckless. It's different. Now, if they trip, that's unintentional. And this came back to the discussion we had about this bill in committee. Like, what if an old person trips and falls on a dog and kills it?
Well, there's no intent there. So
that's what I'm saying.
And recklessly would step in.
Right. So is there a value in separating intentionally and recklessly and unintentionally? Because any of those situations could happen.
There is a value.
Okay.
Delegate Williams, are you okay with us separating all that?
I'm okay with that.
Delegate Davis, how would you recommend we do that?
I'm not the person to ask on that.
Well,
I don't like it
look,
at all. So I'm not the person.
I think that the first blush question is whether we want to keep them the same and just leave it intentionally on this end. And I forget how the language is written on the interference. Is it also?
Or Mr. Chair, could we just say just an intentional killing or injury, remove the reckless, and then keep the willful and malicious interference? Does that solve that problem?
Can we define interference?
I think interference is already defined in the code.
Yeah, I think it is.
It's already in the equine
But
statute.
then we wouldn't be capturing people who are like drunk making bad decisions and it leads to the death. So I'm not sure we want to completely get rid of.
But it could fall, I mean.
To get out us.
Well, Lauren's already talked about separating this out, so we could just define it and that would be easy.
Sorry, so did anyone have this answer to this question? If what the penalty is on, you said it was $50? If I kill someone's animal.
$100.
What's that?
I think she said $100.
That it's $100 if I kill someone's animal intentionally, but it wasn't a service animal.
That can't be that low. I think I know somebody who went to jail for that.
Mr. Chair, I think I have a solution. The advocates, you could see we're getting into the weeds here, but this is important for us to separate all this. What are you looking to get at? Is it the intentional act, the reckless act, the unintentional act, the malicious and willful interference? What are you looking to get at here?
No, Ben had to leave.
And we got
everything except for unintentional.
I'm trying to steer us to conclusions.
I think Lisa has her hand
Very
up.
quickly.
Yeah.
I think that we're trying to get at not as much reckless. I mean, reckless, yes, but I think more intentionally. Like if you look at 10606, a person may not intentionally mutilate, torture, or cruelly beat or kill an animal, cause, procure, and or authorize an act, going all the way down. They're guilty of 3 years, $5,000, or both. And that's not a surface animal.
So you're not worried about reckless or unintentional acts?
I don't want to say that I'm not worried about it. I would defer to the delegate about that as well. And it looks like Jennifer's back.
Yeah, apologies. I mean, I was just going to say, I think the animal advocates might be in a slightly different posture than the disability advocates. So I think we're a little bit hesitant to give you a definitive answer to that. I mean, clearly the goal is to ensure that service animals can safely perform their job. I think that does merit a discussion around certainly intentional. I do think the reckless or malicious is an important piece to capture, though, because there are scenarios in which you could see somebody sort of taunting or doing potentially harmful things to these service animals, maybe not intending to fully strike them or fully connect with them, but that are putting these dogs and therefore their people in jeopardy. So I think that a crime against these dogs that's completely unintentional, Delegate Conaway's dog jumping the fence, I don't believe it is our intent or the advocates for the disability advocates intent to capture those scenarios. But I think that willful, reckless scenario is important to have some consideration for.
I agree. I'm not an attorney, so if those need to be separated, I completely agree. But the goal 100% is.
How about the malicious interference?
I think that we would be uncomfortable with that. We would want that to be the law.
To me, that goes back to them being able to safely and confidently enter any public space and do their job. And there is a serious threat to the handler if the dog is maliciously interfered with, because if the dog can no longer confidently perform its work, then it is putting its handler in severe danger. So I think that is a legal standard that should be at least, analyzed in these amendments.
I'm just trying to help you here.
We don't have all the
Thank you, Jennifer. I'm not a lawyer, so
the chair's going to cut this. So
I'm about to cut it all off anyway. So, all right, it's we're 15 minutes over. Gotta end this. But I think I actually think all this crazy law schooling of this bill made a little progress. So I think we can at least say on optional restitution and interference, maybe in a new section, there's something there. And there's a larger question that, can I just ask the sponsor and the advocates to try and circle back an option or two on how to handle this killing question?
Mr. Chair, can I ask something? I don't want to make a motion, but can I ask maybe someone to work with Lauren to draft what we're talking about here, so we could look at this, a different section with the intentional and reckless and the.
I think it came in more like that.
The original posture of the bill was a separate section, and then I do have an amendment, though we didn't talk about it, kind of amends the original version of the bill. Oh, and then I see Delegate.
Have that amendment, and we could work together to refine that amendment. I think that's a great starting place, because I think it mirrors what everyone's trying to say here.
Right.
Okay. Delegate Davis has a final thought here.
Yes, just finally, I see we're making great progress. I have a question. We had some discussion about what was a service animal. So when you guys come back, can you have that too?
Oh, the service animal is defined in the original version of the bill. Delegate Davis, let me pull.
Is it in the code, I guess?
It is in the code. Actually, it's in the health article. It refers back to,
All right, I'll look at it. Thank you.
Yeah, it is. It is defined in the code.
Great.
Human services.
Oh, sorry, human services article.
7-701.
Okay.
All right, wonderful.
We look forward to seeing
it doesn't include emotional support animals. I wanted to be very clear with that. So it's really only animals to assist someone who has either a visual impairment, a hearing impairment. I can't remember everything else, but it's very specific.
Okay, thank you.
All right, so I guess we got some homework, and we'll see you at the next.
Thanks so much, everybody.
Thanks, everyone.